afternoon. My name is Shalini Hunter, and I am very excited to join the Caltrans team as the new Assistant Director for the Office of Equal Opportunity and Discrimination Complaints. Here at Caltrans, we value our workforce and aspire to reflect this state's most valuable asset, all of you. As a result, we're looking for opportunities to share, acknowledge, and celebrate diversity in all forms. Today, we're presenting this video on disability from our partners at the Department of Fair Employment and Housing in observance of Disability Awareness Month. But before we get started, I want to take a moment to welcome all of you and also to make one comment on our topic. So when you think about disability, I want to encourage you to think of it as a skill set. It means being mindful of the disabilities of people. It's not just the awareness that discrimination on the basis of disabilities is unlawful. It is an awareness that should help inform how we accomplish our day-to-day work together in ways that actually transcend our abilities. With that, I do have the pleasure to introduce our webinar speaker, Mr. Brandon Butler. He is an attorney, he is an expert on civil rights, and for nearly a decade, he was the senior attorney of the Fair Housing Center for the Legal Aid Society of San Diego, where he was instrumental in creating the first Fair Housing Services program. He began his career as a housing advocate at Communities Actively Living Independent and Free, a disability rights organization in downtown LA, where he advocated for housing rights for persons with disabilities. And he's currently the Assistant Deputy Director of Education and Outreach at the Department of Fair Employment and Housing. And I can vouch for him. He is a fantastic educator. Today, he will be talking a little bit about the history of disability awareness, the protections afforded to those with disabilities, and then wrap up with some comments around COVID-19. Welcome, Brandon.
All right. Well, good afternoon, everyone, and thank you, Shalini, for the wonderful interview. And we're so proud of you in your work at Caltrans, and your work at the department will be missed, but we congratulate you on your work with Caltrans. So yes, as Shalini said, it's a pleasure to be here, and I'm going to go ahead and share my screen here, so bear with me as we go to the future here of technology and training. Here we go. And then we'll get started with our discussion today. So just let me get it all set up here. Okay, so as Shalini said, it is a pleasure to be here. October, which is National Disability Employment Awareness Month, and it's an important month, and it's actually an awareness month that's been happening for over 75 years. This year's theme, as put out by the federal government, is increasing access and opportunity, and I think that's an important message when we think about that many folks who are working, who would like to work, are persons with disabilities, and the idea that our laws afford the ability of folks to increase the access and ability to work is a critical civil right that we will talk about today and kind of where it came from. But first, you've already heard my introduction and kind of my connection in the disability rights sphere. I work with the Department of Fair Employment and Housing, which, if you haven't heard of us, which many folks have been around for over 60 years, but many folks haven't heard of us like they have heard of Caltrans. We are California's civil rights agency, so we work for you. We are the largest civil rights enforcement in any state, and we enforce all of California's civil rights laws, which I'll kind of run through for everyone's awareness today in our discussion. And the mission of DFEH is to protect the people of California from unlawful discrimination in employment, housing, public accommodations, and from the perpetration of acts of hate violence and human trafficking. I'll note that during COVID, unfortunately, there's been an uptick in hate violence against members of our Asian communities throughout California. And so just a special emphasis on that. Regarding what we do at DFEH, we engage the public in outreach and provide technical assistance to employers like you're hearing today. We also investigate discrimination complaints in cases of systemic discrimination, which is probably, if you've heard of us, what you may know us for is that we actually investigate complaints of discrimination throughout California. We also facilitate mediation and have a dispute resolution board at our office, so we're able to hopefully resolve cases more simply through mediation. But where we can't resolve cases, we do enforce the law in civil court. So in that respect, we are a public civil rights prosecutor in that sense, that we will file lawsuits in civil court to protect the rights of Californians. So that's what we do at DFEH. And our a little bit about my connection and my background, uh, uh, to the disability community is, I guess it started out, that my father was a high school education teacher for students with developmental disabilities for over 30 years in Riverside, for Riverside County. And I went on to also, kind of anecdotally attend the wheelchair basketball Olympics game and match in Los Angeles in 1984. And then I've also been a supervisor of independent living skills for persons with developmental disabilities. And as Shalini mentioned, I worked at Communities Actively Living Independent Free as the housing advocate doing civil rights work. And then my time as a legal services attorney prosecuting discrimination cases in housing for persons with disabilities. And so that's kind of my connection to our conversation here today, as we're talking about disability rights. But again, just to kind of talk about the laws we enforce, because that helps us get us into our conversation around the laws of disability rights. First, everyone should know that DFEH, our jurisdiction, really is from the Fair Employment and Housing Act. And this is where we're going to be talking about today when we talk about the rights of persons with disabilities in the workplace. Comes from our government code 12940, where we start discuss employment discrimination. I'll talk about that. This is also where you'll find information on housing discrimination. We also have the Ralph Civil Rights Act. This protects individuals from hate violence or the threats of hate violence on the basis of any protected characteristic, which I'll talk about. And again, we've seen an uptick in our time with DF with the state law. Now, we also have the Unruh Civil Rights Act, which protects individuals from discrimination in harassment in businesses and public establishments. This is also an important civil right that comes up more and more as we talk about COVID, as people are being harassed in the workplace. And that's just going to do one moment here. One moment here. I have to fix something here. Okay, we also covered the Disabled Persons Act, Civil Code 54. This really talks about protecting the rights of persons with disabilities to have the free and full use of all public places, streets and highways and public buildings and hospitals. So we do this. We also cover the Disabled Persons Act. You may not realize this, but we also have authority around human trafficking protection. While we're not a criminal jurisdiction, have enforcement in that area, we do have the civil protection to help the victims and survivors of human trafficking, which is part of our work, including certifying UNT visas for the victims of human trafficking who are involved in a case and need immigration assistance. And then I think importantly, and just kind of to raise awareness, we also cover discrimination around recipients of state funding under Government Code 11135. This protects individuals from discrimination who are recipients of state funding or state financial assistance. So moving to our conversation today, now that you kind of understand who DFEH is and what our mission is, I want to talk about kind of this moment in disability rights. I think this is the 30th anniversary of the Americans with Disabilities Act, which is a historic civil rights law that was probably one of the last major civil rights laws passed in the United States of America. And we celebrate it with this 30th anniversary today, which July was the 30th anniversary, so we can still keep celebrating. I want to talk about what the ADA has brought us in terms of the rights of persons with disabilities to work in the workplace, but I also want to talk about some of the challenges that we may encounter. So, importantly, I like to start the conversation with the ADA was one of these bipartisan civil rights laws that was passed over 30 years ago, or just about 30 years ago. And I like this statement from then President George Bush, who's now deceased. But when he signed the Americans with Disabilities Act, he said, I now lift my pen to sign this Americans with Disabilities Act and say, let the shameful wall of exclusion finally come tumbling down. And I think when we think about what folks were going through in this country to have full and equal access for persons with disability, it was a shameful wall of exclusion. There was high levels of discrimination against persons with disabilities. And we'll see that while there's been a great deal of improvement, problems continue. And I like to highlight this picture when we talk about the passage of the ADA. This is what's called the Capitol Hill Crawl, which happened just shortly before the passage of the Americans with Disabilities Act. And what you see here are disability rights activists who were pressuring Congress to vote on the ADA, which had come up for votes. It wasn't being passed, and they wanted to apply pressure to force a vote. And so people, hundreds of activists, crawled out of their wheelchairs and crawled up the Capitol Hill steps to bring awareness to the need for the Americans with Disabilities Act, which one of the titles protects in employment discrimination, of course, public access, and so forth. But this is a scene to show what folks were going through. And it was a broad-based disability movement of folks with developmental disabilities, physical disabilities, mental health disabilities that would push this struggle for equal rights. So this is one of those famous pictures of the Capitol Hill Crawl that came right before the passage of the ADA 30 years ago. And as I mentioned, this is it's not only the 30th anniversary of the ADA, but the 75th anniversary of the Increasing Access and Opportunity in our National Disability Employment Awareness Month. So this is an important monthly event, or a yearly event for us to acknowledge the work of persons with disabilities. But when we look at the U.S. Bureau of Labor Statistics and we look at what are the kind of workforce statistics for persons with disabilities? When we think back that we've had a civil rights law for 30 years federally, what do we know? Well, what we know is that according to 2019 data, across all age groups, the employment population for persons with disabilities working was much lower than those without a disability. And in 2019, around 19% of persons with a disability were employed, according to the U.S. Bureau of Labor Statistics, reported in a report released in February. In contrast, the employment population ratio for persons without a disability was 66%. So still quite a significant ratio of persons not working who are disabled compared to those who do not have a disability. Let me go to the next slide here. And then across all educational attainment groups, jobless rates for persons with disability were higher than those for persons without a disability. So yet another indication of disability discrimination may exist and is still a persistent issue. The unemployment rate for persons with a disability is at 7.3% in 2019, which has declined from the previous year. And again, this was in our booming economy that was once pre-COVID, and we still didn't see that much of a change. The jobless rate continued to be about twice as high as the rate for those without a disability. So again, we see disparate numbers between those with a disability and those without. And then we also know from the data from the labor statistics that persons with a disability were less likely to work in management, professional, and related occupations than those without a disability. So I think taken together, the history of where we've come from, some of this anecdotal data, we understand that there's still a significant disparity in folks with a disability who are working throughout the United States than those without a disability. We don't have parity, so to speak, right now. And that kind of brings me to what's happening on the California side. So, to get into that, I just want to kind of place into context where does disability discrimination fall? And again, you'll find it in terms of employment disability discrimination, in our Fair Employment and Housing Act. And under the FEHA, as it's known, there are a variety of protected bases that protect folks from discrimination on the basis of who you are. And you see here the list of enumerated protected bases, disability. As you see, it is there, and you'll find out that's one of the highest levels of the complaints we receive. But broadly, I just always want to remind folks that under the FEHA, if there's any kind of workplace discrimination on the basis of one of these protected classes or related to any retaliation, it is protected under our civil rights laws. And in 2019, we've released our 2019 employment filings just actually about 2 weeks from the recording of this, which is October 28th. So this is hot off the press in terms of learning about what's happening with the complaints that DFH receives for discrimination in the workplace. And yet again, as it's been almost every year, disability was the highest level of discrimination complaint that we received at DFEH. And you can see where it relates into other forms of discrimination. Gender and sex-based harassment was also one of the other largest forms of discrimination. But disability was our highest enumerated protected bases. And we received last year 5,183 complaints, but there was a total of 16,528 employment bases of discrimination, because folks may allege more than one complaint. One basis. You could say disability discrimination, or you could also say disability and gender discrimination. So that's why those numbers are a little different. But as you see also in this list, is that we also issued 15,000 right to sue letters in 2019. And right to sue letters, as you may or may not know, is a requirement of any complaint that there be, or of anyone who wants to file a lawsuit in court, that they're able to first exhaust their administrative remedies. And to do that, you have to file a right to sue letter with DFEH. And so some folks choose not to go through DFEH and just file their lawsuit in court, and that's what that 15,000 number represents. People who wanted to immediately sue in court and opted not to have the department investigate their discrimination complaint. And let me just jump to this slide, and then I'll go back for a second. So of those right to sue cases, of folks who didn't file with our office, but just didn't investigate with our office, but just wanted to go to court on their own, you'll see that disability discrimination was again by far the highest, with over 13,000 bases for disability discrimination that were requested for right to sue letters. So in the complaints that you see over here, disability that were investigated by DFH, disability was the highest. 2,868 complaints that we investigated of disability discrimination, but also with our right to sue letters, we had 13,000. So I take these points to mean there's significant discrimination that is being impacted for persons with disabilities in California today. So with that backdrop of the civil rights laws, the ongoing discrimination, I want to talk about one of the real important spots around protecting the civil rights of persons with disabilities, which is in the workplace, which is the FEHA, as I mentioned. And the California Fair Employment and Housing Act, FEHA, requires employers of 5 or more employees to provide reasonable accommodations for individuals with a physical or mental disability to apply for jobs and to perform the essential functions of the job unless it would cause an undue hardship. So this is where the source of law comes from, with the right of reasonable accommodation in the state of California. It parallels the ADA, but under the FEHA, we have this right of accommodation, right? This idea that the employer may have to make adjustments or changes in the workplace to afford a person with a disability the opportunity to perform the essential functions of their job, unless it would cause an undue hardship. So this is that idea. This is where we get to folks need a modified work schedule. Someone may need a physical accommodation of a different type of desk, or a different kind of speech to text software. I mean, all of these accommodations that you can think of are the ones that this is where it comes from. Right, so this is a major civil right protection. This is where most of the complaints come from, which is the denial of a reasonable accommodation. Now, the right of reasonable accommodation can include but it's not limited to the following. So it could be changing job duties because of a disability, providing leave for medical care, right? So we see a lot of this with COVID and that situation. Folks may need leave for medical care. Changing work schedules, which is a common reasonable accommodation for someone with a disability, may need a different work schedule. Relocating the work area, perhaps due to a disability, they need a different relocation because they're no longer able to perform essential functions of their duty at that specific site. They need it somewhere else. Or providing mechanical or electrical aids are basic forms of reasonable accommodation. Now, the other idea of reasonable accommodation, right, this massive civil rights law that provides this protection. In California, we also have this idea that there's the right of reasonable accommodation, but there's also the right of the interactive process. The interactive process is this idea that employers must initiate when an applicant or employee requests reasonable accommodations. The employer must offer to initiate an interactive process when the employer becomes aware of the possible need for an accommodation. So this is this discussion, a really critical discussion that happens between the employer and the employee when we're trying to obtain a reasonable accommodation, to have this discussion about what the employer is able to accommodate, what maybe they're not able to do. Because perhaps it's a burden, undue burden. This is this discussion to try to find a resolution. Many accommodations are resolved here, but sometimes the interactive process does not yield the accommodation the employee is seeking, and they may believe that it's discrimination. They will file a complaint. So, the employer, the awareness of a need of a reasonable accommodation, may come by observation of the employer. They may see someone who needs an accommodation, and it's quite obvious, or because the employee has exhausted leave benefits but still needs an accommodation due to a disability, right? So there's a lot of ways where the interactive process can be triggered. But in California, it is unlawful for an employer to fail to engage in a timely, good faith interactive process, right? So an unreasonable delay, if it wasn't in good faith, that can be a separate violation in our civil rights laws. So there's the right of reasonable accommodation, but the right of interactive process is critical to have this discussion to see if we can't find the right accommodation fix for the employee and the employer. Now, the point of the process is to remove barriers that keep people from performing the job that they could do with some form of accommodation, right? The process requires this idea that there'd be an individualized assessment of both the job and the specific physical or mental limitations of the individual that are directly related to the need for reasonable accommodation. So this is a very critical process where we take into account all of these aspects to try to resolve and see if we can't find the right reasonable accommodation that may work. So this is an outline. But often, just to kind of let folks know too, like what's helpful out there is the Job Accommodation Network, JAN. It's a toll-free service that advises businesses and individuals about accommodations, and they've reported that most accommodations cost less than $500. And if you're not aware of the Job Accommodation Network, it is a helpful tool that can really give a lot of ideas for reasonable accommodations. Often we have seen the world of reasonable accommodations. And while it is case by case, Jan has been able to kind of give folks a really good idea of what are the basic accommodations and how much they cost and ways to get around some of the difficulties. So I would just kind of give that as an awareness option. Now, the department, as we've been talking about, has also enforces our civil rights laws in California, and I wanted to highlight a few cases that we've resolved that I think kind of show the ongoing work of our office and the discrimination that folks with disabilities face. In this case from 2019 that I've selected, this essentially was a settlement that we reached where an employee in 2018 alleged that a retail clothing store stopped scheduling the complainant after she submitted a doctor's note requesting a change to her work schedule. That was due to disability-related reasons. The employee couldn't both open the store in the morning and close it at night. And the the employer ultimately provided a new work schedule, but significantly reduced the employee's work hours and demoted her. The company also had an quote, fully healed policy that required employees who were out sick to bring in a doctor's note indicating that they could resume full duty before they could return to work. And we found that this was a settlement occurred because this really raised a lot of concerns for us. I mean, one is this idea that a blanket fully healed policy do violate California law. This idea that someone with a disability can never go back to work unless they can show they were quote unquote fully healed. Because what does that do? That really takes away the idea of a reasonable accommodation, an idea of an interactive process where perhaps someone can still do the essential functions of their job just with an accommodation, not necessarily that they be quote unquote fully healed from their disability, which would present a significant barrier to persons with disabilities. I also think this case is important to show that when folks do ask for a reasonable accommodation due to their disability, whether or not the accommodation is granted, should not be a reason to retaliate against someone with a disability in terms of demoting them or giving them a different work schedule as a form of retaliation, which can be a separate civil rights issue and complaint, right? Not only the denial of a reasonable accommodation, but the idea that now there will be retaliation for exercising a civil right. Now, another case I wanted to mention was a case from a couple of years ago, but is public that I wanted to mention. And this was really around a car dealership, and the long short of it is we had a new worker who was hospitalized for 3 days because of their disability, and they were not able to work due to this emergency hospitalization. And essentially, when they told their employer about this, they were essentially terminated from the job when they said they were unable to work due to their disability. They were denied the idea of a reasonable accommodation, and they essentially failed to engage in the interactive process in total. So this is another example where folks are entitled to ask for reasonable accommodation. You can't be terminated because you may need an accommodation to do the essential functions of your job. So even an emergency hospitalization should not be. There's a duty to engage in an interactive process by the employer to find that accommodation for the employee as opposed to terminating them. And in another case that was from last year, and this is kind of near and dear because I am a person with a disability as well. I'm a type 1 diabetic, and this case is one that was against Chase Bank, and it settled for $60,000. And this is where we had a former employee who worked at a branch bank in Hayward, and basically they had diabetes. And they alleged that the bank, Chase, had failed to provide a reasonable accommodation for the employee to take additional breaks to manage their condition. And as you know, folks with diabetes may have to test their blood sugar, may have to take insulin, may have to have low blood sugar. They may need some additional breaks due to their disability or additional time to manage their health condition. And here they allege that there was a failure to engage in the interactive process to provide an accommodation, and that this person was actually felt they were harassed. So again, this case, these factual scenarios do play out quite frequently, and again, as you've seen in all the years of our complaints at DFEH, often every year in employment discrimination, disability is the highest level. These cases reflect some of the ongoing struggle that persons with disabilities face in light of our important civil rights laws. So we've talked a little bit about the history. We've talked about a little bit about state law. I wanted to jump into the discussion and talk about COVID-19 and the right of reasonable accommodation for employees with a disability, and also lifting up the situation of what about folks who have or members of a vulnerable population due to their health condition. So let me try to highlight this. So with the background we've talked about today, I wanted to talk about the situation. What if an employee cannot come to work because of illness related to COVID-19? Are they entitled to a reasonable accommodation for a disability? And the answer is maybe, right? These are all case by case. All employers, as we've said before, 5 or more, have a duty to make reasonable accommodations when the employer knows of the disability, unless the employer can demonstrate after engaging in the interactive process that would impose an undue hardship. So we know that telework is a familiar form of accommodation, and I think in COVID, all of us have been doing some form of telework just because of the pandemic. But for many folks with a disability, when folks may be coming back to work, this may need to be a form of accommodation due to their disability, uh, as well as whether or not someone's COVID-19 diagnosis, results in disability is a fact-based determination. So having COVID-19 in and of itself may or may not be a disability. It depends if it presents a limitation to a major life activity. But certainly employers should consider telework and leave as reasonable accommodations for employees with illness related to COVID-19, unless it would impose a hardship. And you may be asking, what are some of those hardship factors? Factors you want to consider when you go through this are going to be, the number of employees the organization has, the size of the employer's budget, the nature of the business operation. So these are some of the criteria that go into this distinction of whether the accommodation poses an undue hardship. But certainly COVID-19 has presented this idea that folks are going to need reasonable accommodations because they may not be able to work in the workplace due to their disability, or because they have COVID-19 and it's resulted in a disabling condition. Certainly reasonable accommodation is going to be available. And then that brings the question, well, what if, does I have a medical condition that increases my risk to get a severe illness from COVID-19? Am I automatically entitled to an accommodation? So, according to the CDC, people of any age with the following underlying medical conditions are at increased risk for severe illness. So we know cancer and chronic kidney disease and type 2 diabetes, sickle cell anemia, heart conditions, right? These are all put you at risk of severe illness for having, if you get COVID-19. Now, if that's the case, and your underlying medical condition is a disability, then the employer is going to need to reasonably accommodate the employee unless an undue hardship, right? So you may have one of these underlying conditions that put you at severe or increased risk, but the underlying condition still has to be a disability. So if the underlying medical condition does not rise to the level of disability, employers are not required to reasonably accommodate the employee, though we at DFEH suggest that the employers endeavor to accommodate workers who are or may be at increased risk for severe illness from COVID-19 as a general strategy to keep workers safe and healthy. So, so a little bit about, I think, where we're heading with COVID-19. And I think where we're heading with COVID-19 is when folks do come back to work, many folks are going to need a reasonable accommodation. And we'll be going through these interactive process, and we'll be going through this analysis as folks do return to work. So just kind of to flag this need for folks, it is critical. And I just also want to mention too, because it comes up a lot when we talk about disability, and many folks who may be older Californians, is that if an employee is vulnerable to severe illness from COVID-19 due to their age, that's not a disability, right? So if you have an underlying disability condition, that's you're disabled. But if I'm over 65 and I do not have a disability, I'm not entitled to a reasonable accommodation because I'm not disabled. And a disability, again, means having a limitation to a major life activity. And age is not a disability alone. And we could talk about medical documentation, but just know broadly that, when an employee requests a reasonable accommodation, employers may request reasonable medical documentation confirming the existence of the disability and the need for reasonable accommodation. But we also mentioned during the pandemic, it may be impractical to obtain medical certification at a time like this when, it seems like every time we look, numbers start to uptick, and therefore it may be more difficult to get documentation. But still, documentation will be needed. But DFEH recommends waiving such requirements until the time the employee can reasonably obtain such documentation due to COVID-19 and difficulty of getting documentation. And another thing I wanted to mention, because as I said, many folks are working from home. You may be watching this from home right now. And the question comes up that we receive is, during a pandemic like we're in now, must an employer continue to provide reasonable accommodations for employees with disabilities that are unrelated to the pandemic? Right? So we have folks who have who obviously were disabled prior to the pandemic and maybe have accommodations in the workplace that they may need now. And yes, an employer's responsibilities to individuals with disabilities continue during the pandemic. So if an employee with a disability needs the same reasonable accommodation at a telework site as the workplace, the employer should provide that accommodation absent undue hardship, right? So if it was a certain, software on their computer that's needed now, et cetera, that continues into the workplace. So it's not like it stops because the work is happening remotely. And again, in the event of an undue hardship, the employer and the employee should try to work together to see if we can't find an alternative reasonable accommodation. So a lot of this is working together to find that option, but ultimately, if there's not a resolution worked, someone may file a complaint, and DFEH will have to decide, or a court will decide whether the discrimination existed. So just a reminder that the accommodations are ongoing. And then we have a lot of resources. I mean, right here on our website, I just wanted to highlight that we do have resources on COVID-19, and I was reading from our employment FAQs. Feel free to read our employment FAQs. There's a lot of information there, and more than I could get into during our discussion today. But if you go to dfeh.ca.gov, you will see additional resources that you can get into. Now, I thought, we've kind of talked about a lot of the discrimination that folks with disabilities are facing, which still is ongoing. But I also wanted to leave us with some inspiring notes about looking forward for persons with disabilities in the employment context, and kind of hope. Where can we be hopeful in light of the past and the current situation? And the first thing is, we know there's substantial potential for job growth among people with disabilities and well-paying occupations over the coming decade, something according to the Federal Office of Disability Employment. So that's good news. And we also know that there's going to be substantial growth in occupations where disabilities are likely to be irrelevant, from occupations where there's no physical activities or may have little or no importance. We know most job growth are going to be in occupations where computer use is important. And with the rapid development of computer and information technologies and particular benefits, many people with disabilities are going to be overcome physical and cognitive limitations, and this will significantly increase workplace productivity for persons with disabilities. And I think we're seeing it right now. Right, with COVID-19, many folks have been working from home, and it's really changing the paradigm of work. That working from home and computer technologies are allowing folks to complete their work in a way that's opening doors for persons with disabilities. And so, one of the things I found in the New York Times this last week that I thought was really important was from the columnist Thomas Friedman, and his opinion piece was called "After the Pandemic: A Revolution in Education and Work Awaits." And his quote was, "As more work becomes modular, digitized, and disconnected from an office or factory, many more diverse groups of people, those living in rural areas, minorities, stay-at-home moms and dads, and those with disabilities, will be able to compete for it from their homes." And the point of his article, and I think relates to our conversation, is that this COVID-19 crisis that we've been in, if there's any kind of positive or silver lining that comes from it, is this idea that technology is opening doors for persons with disabilities to compete in the workplace and obtain employment where perhaps before they were unable to, and this is opening a door. So I think COVID-19 may give us a reset and in the workplace, as well as provide us new technology that are going to allow persons with disabilities to be in the workplace where they haven't been before. So I think there is some positive information as we struggle through the pandemic that seems like it just will never end. But maybe when it does end, there'll be some opportunities that didn't exist for a lot of folks because the notion of work is changing, and perhaps there'll be some opportunities open for persons with disabilities that there wasn't before. And I want to leave you with a quote from President Bush, again from the historic signing of the Americans with Disabilities Act 30 years ago in July. And the president said, "And I now sign this legislation, which takes a sledgehammer to another wall, one which has for too many generations separated Americans with disabilities from the freedom they could glimpse but not grasp. Once again, we rejoice as the barriers fall for claiming together we will not accept, we will not excuse, we will not tolerate discrimination in America. And I think, we can leave in that inspiring note that we have a ways to go with preventing disability-based discrimination, but we've really come a long way, and persons with disabilities have new civil rights that didn't exist 30 years ago, but we still have a ways to go. And hopefully, with some of the new technology, with the awareness that we've done here together, we'll be able to continue the civil rights mission, and persons with disabilities will continue to have new opportunities in the workplace. So with that, I want to thank you, and I really appreciate the opportunity to be here today and connect on Disability Employment Awareness Month. And I'm always available for questions. If there's anything I could ever do, feel free to relay to Shalini, and we'll be more than happy to provide additional resources. So again, I thank you for your time today. And with that, I'll hand it back to my friends at Caltrans, and I'm going to stop sharing. And with that, I'm going to pass it back.
Thank you, Brandon. That was great. And thank you to everybody who tuned in and helped us celebrate Disability Awareness Month. And as Brandon said, we are happy to take questions. You can contact us at the Office of Equal Employment and Discrimination Complaints. And feel free to call me directly as well. Thank you, Brandon.